Canada has approved entry for more than 17,600 people with a criminal record in last decade. U.S. citizenship is often seen as permanent, but there are surprising ways it can be revoked. From committing fraud during the naturalization process to serving in a foreign military or government, certain actions can trigger serious consequences. Many citizens are unaware of these risks until it's too late. Understanding these scenarios is crucial to protecting your status. If you are interested in this topic, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. Canada approved 17,600 rehabilitation applications from people with criminal records hoping to enter the country in the last decade. Immigration, Refugees and Citizenship Canada has confirmed to CTV News. From 2014 to 2024, more than 25,350 foreigners submitted an application to have their criminal record forgiven so they can enter Canada, whether on a work or study visa, to apply for permanent residency, or for a short-term visit. Of those, nearly 70% were approved, nearly 20% were refused, and about 10% of applications were withdrawn. Canadian safety will always be our top priority, wrote IRCC spokesperson Remy Larivière in an email to CTV News. Decisions to approve or refuse a rehabilitation application are made by experienced immigration officers, based on legal criteria and a detailed review of the facts. People with past convictions outside Canada must demonstrate they have been rehabilitated and do not pose a risk to Canadian society, Larivière also said. IRCC does not filter the applications for the type of criminal activity. The department also did not specify how many applications were for people hoping to visit Canada for a short period, versus work, study, or a permanent residency application. IRCC also does not filter for the applicant's country of origin. Immigration and refugee lawyer Chantal Delogès said in an interview on CTV Your Morning that everyone with a conviction must submit a rehabilitation application before being allowed to enter Canada, with the process being the same whether they've committed a crime or violated federal law. For example, Delogès said, she had to complete an application on behalf of a client who was convicted of hunting ducks out of season, and who would not have been able to enter Canada without approval from IRCC. The vast majority of these offenses are pretty minor, Delogès said. I mean, when you hear these terms like foreign criminals, it sounds very scary. Rehabilitation has been a long-standing practice, with provisions that have been outlined in the Immigration and Refugee Protection Act since 2001, more specifically under paragraph 36(3)(c), Larivière wrote. This is not about forgiving crimes. These provisions are applied cautiously, and on a case-by-case basis. To have a rehabilitation application approved, Larivière wrote, a person must show that 5 years have passed since the offense or completion of their sentence, and demonstrate they are unlikely to commit further crimes. All applications, Larivière added, are assessed by an IRCC official who takes into consideration the nature and seriousness of the offense, the amount of time that's passed since it was committed, evidence of good nature since, the applicant's community support, as well as other factors. Delogès said while the process to submit a rehabilitation application is the same whether the applicant committed a crime or violated any federal law, the screening by IRCC officials is much more rigorous, depending on the severity of the crime. The more serious the offense, the less likely it would be that it would be granted, she said. According to IRCC, individuals must still meet all other requirements for a visa or immigration program. This process has helped reunite family members and spouses of Canadians, and allowed performers and professional athletes to enter Canada, despite having a criminal conviction in their past, Larivière wrote. Approval for rehabilitation simply renders the individual not inadmissible due to their criminal past. It does not automatically grant entry to Canada. Calling the number of people with prior criminal convictions who are approved for rehabilitation a drop in the bucket compared to the total number of people visiting Canada every year, Delogès added a successful application does not necessarily mean the individual has already entered the country. Some people, they just want to clear it for the future, she said. I've had people that want to apply for it for information only, so that they just know that they could come back in the future if they wanted to. Asked about concerns that people facing deportation from the United States might try to come to Canada, Delogès said it's quite possible, but added that Canada's inadmissibility laws are stricter than they are south of the border. The US is more concerned with crimes that have some sort of depravity attached to them, or what they call crimes of moral turpitude, whereas ours is much more black and white, she said. If you have a conviction, it almost doesn't matter what it is. It will make you inadmissible if you're a foreign national. There are some exceptions, but they're rare. Deloges cited the example of a conviction for driving under the influence. Someone with such a conviction would be unlikely to have any issues entering the US, but trying to enter Canada with the same record would be extremely serious, she said. Losing US citizenship is rare but not impossible. This video highlights how vital it is to stay compliant with immigration and national laws. Whether you're naturalized or born in the US, being informed is your first line of defense. Awareness today can prevent regret tomorrow. That is all for today, in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later, in the next video. Till then, take care.